That is the
Yesterday it was sent through email, my lord. But despite that, my lord, it is not.
It has not come. Similar is my provision.
please, you will have to adopt the proper procedure. Please send it through email. We will get it listed. Don't worry.
Yesterday,
Why we won't list? It's a typographical error from our side. Why we won't list?
yes, typical error from.
Yes, why we won't list? We will list it. You don't worry. You'll have to follow the procedure.
Since it was done
Email
yesterday.
through email before 12, but it has to be
Yes,
before 12.
it was done yesterday before 12.
Yeah, I'm sorry because now I'm not the senior most here. So the senior most will decide over how to take up the matters.
This code is the senior most. Today.
No, today,
I have sent
but
yesterday.
for tomorrow, the other senior judges will decide. I won't be the senior most there for tomorrow. I'm really sorry.
Now we are mentioning my lord for today itself.
You'll have to do it as per proper procedure. You'll have to send it through email. I'm really sorry. You'll have to send it through email.
Since it was done yesterday, but not posted.
Yes, I'm sorry. But you'll have to send it through email.
Obliged, sir.
Before 12, but
May
not
I please-
after 12.
May I please, Your Lordship?
Mm.
Well, in item number 11, we have filed an additional affidavit
Hmm.
yesterday. That
Mm.
has not been come into record. That may be called for.
Lordship, item number,
Similar for item number 17. ma'am.
look up. Okay.
Lordship, item number 13 and 14, yesterday we have filed one additional affidavit, but it has not come on record. Lordship.
We'll get it.
Obliged, Lordship.
Item 1. May I please?
Yes.
CD was called for on last purpose.
Oh,
My lord, in this case, my lord, case that was not called for, my lord.
it was
Because
not
it
called
was,
for.
it was listed on, my lord, 26/9, my lord.
Ah,
Then, my lord, the learned council, my lord, he paid to, my lord, release the matter before the vacation, my lord.
hmm.
CD was not called for.
Call.
We'll call for the CD then.
Yes.
Call for the CD, leave the matter on. When do you want? After vacation?
21.
21. 22nd,
The 23rd, my lord.
23rd.
23rd.
May I please, your
Oh.
lordship?
My lord, here in this case, petitioner was behind the bar since 17/3/2025, lordship. Lordship, charge sheet already filed, lordship, and 4 witnesses already examined, lordship. Lordship, here in this case, lordship, your lordship may kindly peruse the FIR, lordship.
POSCO? Is it under POSCO?
POCSO, lordship.
We have to issue notice to the victim.
No, lordship. But lordship, here, lordship, the arrest itself is illegal because grounds was not.
No. See, we
That is
have to
different
issue
aspect, my lord.
notice
First notice has to go, my lord.
Yes, lord.
to the respondent number 2, not the victim, respondent number 2.
Scan copy may be called for and, my lord, notice may be issued, my lord.
Petitioner to take steps to, petitioner is represented. Stop. Petitioner to take steps to issue notice to the respondent number 2. Returnable on, when do you want?
Any day.
22nd October. Meanwhile, call for the scan copies of the trial court records along with the scan copies of the CD.
My lord, steps through the
Yes.
PP office, lord.
Yes, you can take steps to the PP office. It is not required to be recorded.
Yes.
It is not required, my lord.
Item 3.
May I please, your lordship? My lord, here also such-seated case, my lord.
Hmm.
Very unfortunate. He is the father of the alleged victim, my lord. He is in jail since 255 days. A short date may be given, my lord. In the meantime, LCR may be called.
Okay.
Special just
This is under POSCO.
POCSO, my lord.
Okay.
Because
you have to issue notice also.
Both minor, the daughter also minor,
Hmm.
the offense committed, the boy also minor. The juvenile declared that boy and that case is trial in juvenile court.
22nd October.
Yes.
Meanwhile, call for the scan copies of the trial court records
Special just, my lord,
along with the scan copies of the
POCSO
CD.
Lakhimpur, not Lakhimpur.
Oh, 22nd October, Lakhimpur.
Pending case, my lord. Trial stage.
It will come. 22nd October, it will come.
Item 4.
Irregular bail application, lordship.
Hmm.
Kindly see the, my lord, FIR at page, my lord, 9, my lord. Now here, my lord, the victim is the, my lord, a mother of 2 children who is, my lord, 21 years old. He is also a, my lord, a short film maker and dancer as well as, my lord, YouTuber. The petitioner also, my lord, YouTuber. They made some program and My lord, item 5 may be taken after some time, my lord.
Okay.
Item 6.
May I please your lordship?
Mm.
My lord, there is a POXO case under section 10 of 10, my lord.
We issue notice.
And
11
I am
of
behind the buffer
KK
for 42
Alga
days.
is present for the petitioner. Full stop, petitioner to take steps to issue notice to respondent number 2 returnable on when do you want?
17 on
1710. Meanwhile, call for the scan copies of the charge sheet has been submitted.
No, my lord,
We,
investigation is present.
Call for the CD.
publish.
Item 7.
17.
My lord, here is the case, my lord, where the police is searching the petitioner to arrest him, but no case has been registered as inquired by the my lord petitioner. Now, lordship will find at page 10, the RC my lord, registration number of a particular vehicle. Petitioner is the owner of that particular vehicle. That was given hire to on Rohim Ali, who carried 3 cows. It has been alleged that the cows are theft by Rohim Ali. Now, since my vehicle is involved, police is searching me, but no affair has been lost as on date. So, my lord, let instruction be sought for, my lord. In the meantime, he may be protected, my lord.
Let us take instruction, my lord. So let the matter come up tomorrow, my lord. Will first, my lord, whether any affair has been registered or not, that inquiry will make, my lord.
Tomorrow,
Tomorrow, my lord, will adopt the instruction.
for a report from the, what is, Colvisia? Colvisia PS.
For call disappears, my lord.
Colvisia PS, if any case has been
Yes, my
registered
lord.
against the petitioner. The Middle Islam with respect to any cattle theft case.
Obliged.
Item 8.
List 9, list on 9.
That please, your lordship, 482 bill
Mm.
application, but FIR is in page 13 and it's not 2, my lord. Relevant person is page 16. Well, allegation is, my lord, criminal trespass and house trespass and voluntary causing hurt, my lord. And attempt to murder, my lord. Well, FIR is in page 16, my lord. The type copy, my lord. My lord, the allegation is totally, my lord, fabricated, my lord. Kindly see the paragraph 4, my lord, in my petition, my lord. Paragraph 5, my lord. Paragraph 4, my lord. Page number 4, my lord. Paragraph 5, my lord. The actual fact is that, my lord, I'm reading, my lord. The petitioner begs to state that on the alleged that in the evening, the petitioner was bringing his cow from the field at the time without any reason. The informant's husband obstructed the petitioner in front of the pathway of his house. The informant's husband had a knife in his hand. The present petitioner requested him several times to move aside and let the petitioner go, but the informant's husband did not relent. And when the petitioner attempted to chase his cow aggressively, it got startled and started to run. The informant's husband got entangled with the tether of the cow and fell into the ditch and got injured. This is the actual fact, my lord. My lord, nothing has happened as alleged in the FIR, my lord. My lord, I am a government employee, my lord. Yeah. So, my lord, case diary may be called for, my lord. In the meantime, I am being protected. I am a government employee. If I am arrested, my lord, I will lose my job, my lord. Case diary may be called for along with the medical report, my lord. In the meantime, I may be protected, my lord. And in this regard, I have also lodged an FIR. That is, my lord, annexure 25, my lord. This is my FIR, my lord. I am a government employee, my lord. If I may be arrested, my lord, I will.
FIR name accused person, my lord. So case diary along with the medical report may be called for, my lord.
In the meantime, maybe I may be protected, my lord. I'm a government employee, my lord. I may arrested, my lord. I will leave my job. Considering this, my lord, I'll fully cooperate with the investigation, my lord. I will not tamper with the evidence.
Okay, then. Interim
My,
bail.
my objection may be recorded, my lord.
Heard learned counsel Mr. B. Buragohai.
Yes, my lord.
For the petitioner who has filed his application under section 482 of the BNWS 2023 with prayer for plea arrest bail, as he is apprehending arrest in connection with students of PS case under students sections. Heard Mr. R. Burwa, RJ Burwa, no?
RJ Bora, my lord.
RJ Burwa, learned additional PP Assam, who has raised serious objection against the bail petition stating that the petitioner is an FIR named accused and he has acted in an aggressive manner. The allegation against the petitioner is that there is a long standing dispute between the petitioner and the victim. Full stop. The petitioner attacked the victim, causing grave injuries, leading to profuse bleeding. Full stop. The victim was saved by his neighbors and he is undergoing treatment. Full stop. It is submitted on behalf of the petitioner that the petitioner and the victim were quarreling with that a quarrel, petitioner and the victim, no, that a quarrel broke out between the petitioner and the victim relating to harnessing the petitioner's, whose cow was it? Petitioner's.
Yes, my lord.
Petitioner's cow, full stop, during the quarrel, the victim got entangled with the harness and fell into a drain,
Yes, ditch.
fell into a ditch and sustained grievous injuries. Full stop. It is further submitted that the petitioner is a government employee and he will never indulge in such government employee, and a false case has been and a false case has been brought up against him. The petitioner is being a government employee is not a flight risk. I have considered the submissions at the bar with circumspection. It appears that interim bail may be granted to the petitioner. Call for the CD, list the matter on.
24.
Just a moment, you see, there's a, have you moved anticipatory bail in the district sessions court?
No, my lord.
My lord, that will be required, my lord. Personally,
Recent
decision of the
judgment
honorable appellate.
judgment has been stayed, I think. Somebody from our court has.
That I am not aware, my lord, but my lord, recently, my lord, Supreme Court has ruled, my lord, that before, my lord, filing application before the honorable High Court, my lord, there has to be, my lord, he has to file anticipatory bail application before the session judge. If it is state, my lord, I am not aware.
No.
Sessions court.
No, madam. I have not.
I don't know, we're relating to stay and preferring a reference or something like that.
The step part, I am not aware.
I also am not aware, but somebody I have heard verbally, not through documents.
Yes, ma'am.
I think you will have to prefer an application before the session judge as per the direction of the Supreme Court. First, initially you'll have to prefer an application before the session judge.
In that manner, I will approach before the learned court, session court, but till that I may be protected, my lord.
No, that will be in fact, my lord. He will get protection from this honorable court, and then how can he approach my session judge, my lord?
Instead of granting interim bail, I think we'll call for the CD. CD call korle bhalo. Because we have the judgment. And if there is anything contradicting it, then you can place the submission. We'll call for the CD. Meanwhile, we'll call for the CD. I know about the judgment. There is a reason.
My lord, I will approach the learned court below, my lord.
Let him withdraw, my
protected, my lord.
No, that is why I'm not willing to protect you. Because
Any court
if we have the direction that High Court should not encourage.
I'll file the application before the court below.
I know
Let
that quotation
Any
correctly.
courtship action may be taken.
I know that quotation. High Court should not encourage anticipatory bails anticipatory bail preferred
That's true, my lord.
prior how, yes?
Without approaching the session
Well,
judge, my lord.
Huh?
Without approaching the
Approaching
session
without
judge, my
something
lord.
like that,
Yes,
yes.
that is my lord.
Yes. So I think I'll,
No, my humble
got the
suggestion, my
order.
lord, let him withdraw his bail application, and let him prepare an application before the session judge, my lord.
I will file, my lord, the application before the.
If this
Bill,
court
my lord.
protects, my
Because,
lord, if this court issues any protection, my lord, then my lord, there is no ground.
No
my
any
lord, to-
instruction has-
in case that will be faster procedure. Faster, I think it will be, I think you'll get a faster result. Why I'm saying, you'll withdraw this application, then you'll approach the higher sessions court. As soon as sessions court reject it, we can approach this court. So it will be much more faster.
My lord, I will apply, my lord, but my lord,
But
problem
if
is that
you're, it's my advice for
some
you.
protection may be given,
If
my
your-
lord.
If your case is pending, then sessions
He'll
judge
file
will
the application.
dispose of your
He'll
case.
file the application, my lord.
I can call for the CD. If the case is pending, then session judge will not dispose of your
Yes,
case.
yes.
Yes, but that will be again problem for him.
Yes, yes. Session judge will not dispose of your case. They, as the case is pending before this court.
But some protection, my lord, may be given, my lord. I will approach, I will approach.
Protection I'm
Mr.
not
Lalit.
granting, I will just call for the CD.
I-
But I think you rather take.
My lord,
you
I am
better
a
take
government
my
employee.
advice.
If I may be arrested, my lord, I will lose the job, my lord. That is
You
the
better
problem,
take
my
my
lord.
advice.
Yes,
Sessions courts are open.
My lord,
We are not, they are not in vacation,
will-
they are open.
I will approach, my lord, I will approach, my lord.
No,
But
no, you're not getting
some-
me.
Yeah,
not getting
it is
me.
what there is what I'm saying. It will do
You
good.
think about it, I'll hold it for a while. Think about it.
Oblige.
কাটিব নালাগে। কাটি দিয়া।
My lord, I want to withdraw this case, my lord. I will fight.
Learned Counsel Mr. B. Buragohai has prayed for withdrawal of this application. The petition is dismissed on withdrawal. Had Mr. Had Mr. R.J. Burua learned election to PSA.
Pending item
Oblige.
5.
Might be lost.
Yes, yes.
Yes, people was purely civil matters, page 11, all kinds. Allegation is that she wanted to have the marriage, he refused.
সুবিধা হ'ব বেলেগ।
Yeah, please, lordship.
Mother, whether in this case also, mother, whether they have
Same question.
approached the session judge, my lord.
You are
that is-
sitting now,
Lordship, no.
while I was discussing about AB. So have you applied for bail in the sessions court?
No, 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 lordship.
No. So what do you, what do you think you should do? You should continue with this or you will apply for bail in the sessions court?
Lordship, I will apply before the session.
You'll withdraw this?
Lordship.
Learned Counsel Mr. N. Hawk
Lordship.
has prayed for withdrawal of this petition. Learned Relation PP Mr. Ajay Bora is present. Petition is dismissed on withdrawal.
Lordship. Oblige.
Item number 8.
Please, lordship. The 125 CRPC has been filed in the court of principal judge family court by the wife, mother. On 2024, my lord. So, during pendency of the case, my lord, an application has been filed by the respondent wife for interim maintenance, suddenly, my lord, on 5/8/25. The day itself, mother, the impugned order has been passed to make payment of 9,000 per month with effect from the date of filing of the original petition. No hearing, nothing else. I have prayed for adjournment on that day because I am a constable. I am a constable at present. I am posted at Saudia. So I could not appear before the Borpata court.
Issue notice. Issue
All right, mother, there was 13 is the date. So in the
How much you are about asked to pay?
9,000 per month, madam. Because
Do you have a
asset,
child?
no, sir, only 3 months she has stayed with me. Only 3 months. She has admitted herself. The thing is there.
Only 1 month's notice, we will hear you as soon as on return.
Madam, because on the 13th day, I have to reply before the court. What will do, madam?
You
all
take
this-
an adjournment.
So,
I'll record it. You take an adjournment
so,
on that date.
okay.
Learned Counsel Mr. B. Sinha
Yes, ma'am.
is present for the petitioner. First, of petitioner to take steps to issue notice to the respondent. Returnable on date of the deed, 4th November. Meanwhile, call for the scan copies of the, we'll call for the scan copies. You
Yes.
want the scan copies?
Yes, ma'am.
Call for the scan copies of the trial court record. Also issue notice to the, oh, issue notice returnable. How do you want to take steps?
By the external post, my
by issue notice to the respondents by registered post as well as by usual process returnable on. The petitioner may pray for adjournment on the next date fixed and the learned principal judge. Which
since the family ko bahut bata hai.
and the learned principal judge Kamrul Borpeta may grant adjournment on the next date to the petitioner.
Public.
Item 11.
But unfortunately, we just received instructions.
Hmm.
It's a writ petition where we were challenging a disqualification in an auction proceeding by AIBC and MSTC. But we've just received instructions from the client. They don't wish to proceed. They want to withdraw.
They want to withdraw.
Yes. Kindly, my lord, only one indulgence. My lord, kindly record that upon instructions that the matter is being withdrawn.
Yes, yes.
Great.
On instructions from your client.
My lord.
Why don't you want to proceed your, maybe
Well,
you have.
Clients are based in Bombay. So we have, basically, my lord, this is an auction proceeding.
Maybe to get,
This is an auction proceeding. We have been disqualified on a hyper technical ground. So that is the challenge in the writ petition. That we could not have been disqualified. So now, my lord, why they are proceeding to withdraw, my lord, is very difficult.
learned counsel, Mr.
My lord, I am Moinag M. Bose.
M.
Bose.
Bose.
Yes,
You're
with
from-
Mr. Shomnath Das.
Your senior,
Yes, ma'am.
learned senior counsel, Mr. M. Bose, assisted by learned counsel, Mr. S. Das. Has prayed for withdrawal of this application on instructions of the petitioner.
Madam.
Learned counsel, Mr.
D Deca.
D. Deca is present for.
Respondent number 1, Lordship, AIDC.
Present on behalf of respondent number 1. Petition stands dismissed on withdrawal.
Highly obliged, Lordship.
It is recorded, on instructions is recorded.
Madam, great.
Item number 12, 13 and 14.
May it please your lordship. After a long time, I am moving a bail application, getting an opportunity to move a bail application.
Long time I'm sitting on bail application. Sitting for-
Coincidence, my lord.
In this case, we have received the CD from the court itself, Lordship.
Huh?
From today itself, we have received the CD from the court, from this court only.
Okay.
So, Lordship, after some time, so we are going.
No, my lord, may I submit, he can see the case there. It will be sworn. Only on the law point only, nothing else. Now, these persons, my lord, all young guys, my lord, they were arrested, my lord. And today is the 33 days, my lord. All offences punishable till 60, they can be confined till 60 days because offences are punishable to 7 years and less. So now, my lord, what happened in the FIR content of,
Take which case?
my lord?
We'll take which case? What
Well, the
case
first
we'll
one,
take?
12. 12 will do and it will suffice the next two cases, my lord. And my lord, I will not trouble this honorable court by reading the FIR. The gist of the FIR is this, that the petitioner number 1 and number 3 are the directors of a company registered under the Companies Act. Now they used to receive CSR fund, corporate social responsibility fund from various companies. Yes. So for
These
the
are private companies.
yes, from the private companies for the unprivileged students, my lord, education and all such things.
Yes, yes.
Now these two directors, my lord, and one of the employee has been arrested. Why? Because somebody gave an information with regard to that making of some forced Aadhaar card, PAN card. Now these are the directors. They have nothing to do with regard to this. Some employees must have caused mischief. That is a matter of investigation. I am not on that. That is the sum and substance with regard to this. Now police went on the basis of a GD entry, my lord, went read it and some cards and some computer, it has been seized. And thereafter, without notice under 41A, they have been arrested. Now, under the law, a person without a notice can be arrested for an offense which is punishable till 7 years or below 7 years. But there is a sine qua non with regard to this. If your lordship takes up the CRPC once, 35 is the provisions, and it's been backed by Supreme Court judgments, wherein Here is a case wherein the police went in, called the directors, arrest them, along with the employees, took them and no notice, and thereafter FIR was lodged. This is part of the FIR.
No notices were issued.
Notice no issue, not issued. Now, they can arrest a person without issuing a notice also. That is the law. But for that purpose, as per the Ernest Kumar judgment, my lord, copy it there. Copy it the Ernest Kumar. Ernest Kumar judgment is this, that as Ernest Kumar judgment, that they have to make the arrest memo. And arrest memo has to reflect A to E with regard to requirements of 35, 1B, 1B, 2, A to E.
So this is a
Ernest
long
Kumar,
term,
yes.
yes.
Ernest Kumar, my lord, will kindly come to paragraph 7.7 first. A to E. 7.7, my lord, will kindly see. 7.7 it nahi. Two, I think.
It's okay, it's okay. It's okay.
7.1.
7.1.
Yes. Now, 7.1. From a plain reading of the aforesaid provision, it is evident that the person accused of an offence punishable with imprisonment for a term which may less than 7 years or which may extend to 7 years or without fine cannot be arrested by police officer only on his satisfaction that such person has committed the offence punishable as aforesaid. So, this has been a law that has been incorporated, my lord, interpreted and introduced by the Supreme Court on that very basis that arrest was in matrimonial they used to arrest. They use their discretionary powers as a whole and to limit their power, this provision has been added. And for that purpose, 7 years was the benchmark and less.
Yes, true.
A police officer before arrest in such cases has to be further satisfied that such arrest is necessary to prevent such person committing any further offense. So there has to be a finding from the investigation that they may further commit an offense. Second, or for proper investigation of the case, or to prevent the accused from causing the evidence of the offense to disappear or tampering with such evidence in any manner, or to prevent such person from making any inducement, threat, or promise to a witness so as to dissociate from him from disclosing such facts to the court or the police officer, or unless the accused person is arrested, his presence in the court, whatever required, cannot be ensured. Now, these 7 provisions, my lord, as after the Supreme Court judgment, my lord will kindly take up the law that chapter 5 of the BNS, my lord, BNSS, my lord, 35.
This was, Ernest Kumar was for CRPC.
Oh, that is same is
Yeah.
codified as a law, my lord.
Yes, yes.
Because after Ernest Kumar,
Yes, of course.
there has been an amendment to the CRPC, my lord,
Yes, yes.
and this has been codified and exactly same words. My lord, one kindly read it.
Yes,
Any
yes.
police officer may, without an order of a magistrate and without a arrest any person who commits in presence of a police a cognizable offence, it's gone. B, against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence, punishable in prison for a term which may...
I've read it.
Yes. Now, my lord will kindly 2, Roman 2. The police officer is satisfied that such arrest is necessary to prevent such person. So, these 7 grounds has been codified from A to E. That is missing in this case, my lord.
Yes, yes.
And that's been a mandatory violation.
Okay.
So, I am entitled to bail.
Okay.
To substantiate, my lord, the law with regard to this, yes, quote of the yes, 35(3) was violated, my lord, and paragraph 22, my lord, will kindly come to. That satisfaction has to be reasons on record, my lord. Reasons to believe, which should be handwriting in record. Paragraph 22, my lord, will kindly come to paragraph 22. Judgment of the coordinate bench of this honorable court, my lord. It is admitted fact that the respondent number 2 issued authorization of arrest to be responded on perusal of the ground of it appears that
23. Para 23.
22.
All right.
On perusal of the ground of error, it appears certain provision has been assigned for affecting error, but it cannot be denied that there is no proper compliance of section 41, 41A. So 41 is 35 now. Corresponding section 35(3) of BNSS which are mandatory required to be followed. From the view expressed by Honorable Supreme Court, so and so, it is evident that GST is a special
It
enactment.
was 2 or 3?
My
Here
lord,
you were referring to 2 or 3?
my lord,
35.
35, my lord, 35, B2.
But here it is 35(3), right?
35.3, my lord, I will come to that, my lord. I am reading these provisions and thereafter I will come to that. Yes.
Alright.
So, my lord will kindly see. 35.3 of the BNS, which are mandatory to be followed. So, 35.3, including 35 is mandatory. I'll come to that. From the view expressed, so and so, consider a complete code in itself regard to the provisions of search, seizure, and arrest as stated. The provision of Code of Law would be applicable unless it is explicitly implied by the provision of the said Act. But there is a instant case. It has seen that no compliance of 41. What is 41 is 35. CRB corresponding to 35 corresponding to 35.3 of BNS, which is mandatory required to be followed as per guidelines of the Supreme Court in Ernest Kumar versus so and so, my lord. Then again, my lord, the findings with regard to this is at paragraph, my lord, we'll kindly see.
Yes.
Yes. Paragraph 25, my lord. In view of the discussion herein about considering the view expressed by the Honorable Apex Court in the case laws referred to herein above, as well as taking into account a period of detention already undergone by the accused for considering the law laid down by the Supreme Court in Arnab so and so Goswami, as read by the petitioner, this court is considered opinion that custodial interrogation is so and so. It's not necessary. Now, before that, my lord, it has been here in paragraph 24, you kindly see, my lord. The submission made by Gogoi that additional advocate is so and so by the accused before the investigating on 9-6 and 10-6, it appears that the petitioner contents regarding non-service of notice under 41 or 41 of the CRB corresponding to section 35.3 of BNSS 2023 prior to his arrest remains unfettered by a substantial material placed on record by the respondent. In the same time, it is also an admitted fact that while the ground of arrest was communicated to the petitioner at the time of arrest under section 69 of the GST, but reasons to believe forming the basis of arrest authorization were not communicated to the present petitioner. Furthermore, it is also a fact that the accused petitioner is in judicial custody in so and so. So what I am on, that paragraphs, my lord, paragraph 3, my lord, 35, yes, is not been complied with, my lord. And apart from that, are we 30? Yes, right. Yes, it would be here. Another coordinate bench judgment, my lord, will kindly see. The court is asking for this judgment with regard to 35 B to A to E. Paragraph 15, my lord.
Okay.
Paragraph 15, I am reading it. It has been observed by the Apex Court that the law mandates that the police officer effecting an arrest in a case entitled punishment for not 7 years, the fact of and record and reasons in writing, which leads to come to a conclusion regarding the existence of the condition mentioned in provisional content clause A to E of subsection so and so. However, in the instant case, no such basis has been shown by the arresting authority in writing, which leads to arrive to the conclusion that a petitioner may treat in the influence of the witnesses. So this is mandatory. My lord, we can see now, with regard to, my lord, the arrest memo, that is the affidavit prior to that we have filed in, my lord. Can you see the arrest memo? That is at page 39 of the bail application.
All the applications are all those pages in all the applications are similar.
Yes.
So no problem.
No problem, my lord. My lord, can you come to page 39, my lord? This is the arrest memo. And in the Supreme Court, Ernest Kumar, I will again take your lordship to the Ernest Kumar. It has to be filled up in the Ernest Kumar paragraph, my lord. I am showing it, my lord. Yes. 9 again. Yes. Filled up or paragraph to paragraph to filled up. My lord, will kindly page C paragraph page 39, arrest memo.
Yes.
This is as per the Supreme Court judgment, my lord. Now you kindly see name, address, ID, telephone number, arrest informations, name, rank of officer, so and so, ground of arrest, nil, prevent accused persons from committing any offense, nil, reasons why on the basis of in writing is absent. For appear investigation of the offense, nil, to prevent accused person from causing further offence. What is the requirement? That is absent in everything, my lord. Now, my lord will kindly take up, my lord, again, my lord, the Ernest Kumar, that is paragraph. Yes. 275 page, my lord, will kindly see. Directions. Hence the following directions be issued. Kindly see to it, my lord. Once I make it, my lord, everything will be clear. Hence the following directions as issued, page 275, my lord. All the state government to instruct in police officer not to automatically arrest when 498 or section 4 of the dowry provision, but also cases where offence is punished for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine with is registered, but to satisfy themselves about the necessity for arrest under the parameters laid down under 41. All police are provided with a checklist containing specified subsection 41 B2 CRPC. Am I clear, my lord? That 35B2, my lord, A to E. The police officer shall forward the checklist duly filled and furnish the reasons and materials which necessitate the arrest. So it has to be filled up, my lord. It has to be communicated, which has not been done here in this case. What I am submitting, my lord, I have brought one, my lord.
It is in paragraph 11, I think.
Yes, yes, my lord.
Paragraph 11 of.
Yeah, yes. And what I am on, my lord, another additional affidavit I have brought on record, tried to explain with regard to the law. There are 3 stages. So far, 41 is concerned. A person is bought, whether he is required to be issued a notice or not. That is a discretion, that was a discretionary, but it is now mandatory and statutory backed that whether he issued a notice or not, it is his discretion based on well-settled materials on record, which should be in writing, that he can flee from justice. That is E provision, my lord. There are reasons he has to record, that he may tamper with evidence, that he may influence witnesses, that he is further required for investigations. All this is to be backed up by reasons on record in the case diary, which is absent.
Okay.
So in that view of the matter, my lord, and these are young guys, my lord, all only being the director of a company, 60 days mandatory, they are citizens of India, from a very good families, my lord, no criminal background, no nothing. They have been behind the bar, and this Sujoy, my lord, he have a special kind of disease, my lord, wherein whole of the spine, my lord, get, my lord, stiff like a bamboo. And he has been there in, my lord, jail for all these days, suffering a lot. Sujoy, my lord. And for that purpose, with folded hands, I pray before this honorable court, that for these reasons on record, not going into the merit of the case, considering the detention period, my lord will kindly, my lord, allow them on to go on bail. That's my respectful submission. Reasons to bail.
See, here in this case, Lordship, yes, Lawrence Senior Counsel has already stated, Lordship, that though 41 notice 535 notice has not been given, even though, Lordship, that is admitted, that can be, he can be arrested if that checklist is being furnished and checklist is being filled up. And yes, Lordship, it is true, Lordship, that Lordship here the checklist is the some columns of the checklist are blank, Lordship. So, Lordship, now the as per the Ernest Kumar judgment, Lordship, that has to be filled up. That the checklist is the checklist has to be prepared and that has to be submitted before the court on the day itself. Now the question, Lordship, what I am going to submit, Lordship, that Lordship, whether therefore that reason he is entitled for bail or not, Lordship. Whether for that reason he has been prejudiced by any means, Lordship. Because Lordship, this is the procedure, Lordship. That procedure is laid down in our BNSS, Lordship. And as it is a procedural, whether because of some procedural default, procedural lapses, he is entitled for bail or not, Lordship. That's why I am submitting, Lordship, that the Lordship, our latest judgment, Lordship, that Lordship. In this case, Lordship may, Lordship, it has the.
I have the judgment.
Lordship may kindly go through. And here 20.1.7. What does it say, Lordship?
Judgment, did you have it?
Lordship?
You can give it to me. 20.1.7.
20.1.7, Lordship. Here, Lordship, this Darshan Kumar judgment is on the basis of, Lordship, 47 notices, Lordship. And whereas that 47 notice is, we know that, Lordship, that is the mandate, that is the, for that has been, that 47 is the mandate of the Article 22.1. But these are not the mandate of any articles, Lordship. So, Lordship, this is the procedure. Section 35 notice is just procedural. And here, Lordship, 20.1.7. Here in this, Lordship, may I read that paragraph, Lordship? In the present case, the arrest memos and remand records clearly reflects that the respondents were aware of reasons for their arrest. They were legally represented from the outset and applied for bail shortly after arrest, evidencing an immediate and informed understanding to the accusations. No material has been placed on record to establish that any prejudice was caused due to the alleged procedural lapses. Here, there is no any procedural lapses. Because of the procedural lapses, there is no, he is not being prejudiced. Because in 47 notice, everything has been mentioned, why he has been in ground of arrest, Lordship. In the absence of demonstrable prejudice, such as irregularities, at best a curable defect, and cannot by itself warrant release on bail. As reiterated above, the High Court treated it as a determinative factor while overlooking the gravity of the search under Section 302 IPC and the existence of prima facie case. Its reliance on Pankaj Bansal and Prabir Purkayastha is misplaced, as those decisions turned on materially different facts and statutory context. The approach adopted here is inconsistent with the settled principles that procedural lapses in furnishing grounds of arrest, absence prejudice, do not ipso facto render entitle the accused to bail. So, Lordship, here, as it is a procedural lapse, they have submitted it, but they did not fill up that part, Lordship. When in other way, Lordship, 47 notice has been given, in 47 notice, everything has been mentioned, everything has been stated elaborately, Lordship. And they have also got the chance to, because of that, Lordship, it is not that, Lordship, because of not receiving that, not getting that in proper way, they could not avail any counsel or anything, Lordship. So, Lordship, they have not prejudiced from there. Because of that part, they are not prejudiced. So, Lordship, if it is, they are not prejudiced, as per the Darshan's judgment, Lordship, they are whether they are entitled for bail or not, Lordship. As per the Darshan's judgment, Lordship, they are not entitled for bail. Regarding that law point, Lordship, this is my submission. And apart from that, Lordship, their conduct, Lordship. Yes, Lordship, if they are only the directors of that institution or not, it is, but they themselves has admitted, Lordship, they knew that they themselves used to prepare some fake Aadhaar cards. They brought some persons, they gave them the 200 rupees by each of them, and their photographs, they took their photographs and their everything, their details, and thereafter, what they used to do, they used to make fake Aadhaar cards, so that they can avail that, so that this, because of by showing those Aadhaar cards, they can conduct that examination, fake examination, and later part, Lordship, they have taken 4 to 5 crores they have misappropriated, Lordship. So this is not a simple crime, and this is not a in general, Lordship. They are literate person, they are very much aware, they themselves have admitted in their statements, Lordship will find everything is flag mark here, Lordship will go to the CD, Lordship, that Lordship, when thousands of Aadhaar cards they have prepared, Lordship. Thousands, Lordship, not 1, 2, 3, 100, 200. Thousands of Aadhaar cards they have prepared. They have conducted some fake examinations, and by this way they have misappropriated 4 to 5 crores of rupees, Lordship. And these are the persons who when there, they have make the complaint before some of them have come to the police station that they are doing this job. So Lordship, only because of that checklist is not yes, it is not fill up. Some columns are blank. Only because of that, Lordship, whether they are prejudiced by any means, so that they are entitled for bail, that part has to be looked into in this case, Lordship. And at the same time, Lordship, Anish Kumar is also there, Lordship. And at the same time, Lordship, our latest judgment, Lordship, the state of Karnataka versus Darshan, etc., that has also been stated, everything, Lordship.
Yes.
So Lordship, I will submit the CD, Lordship, Lordship will decide on
Yes.
this.
Now kindly see the proposition with regard to law. I'll come to that. On factual metrics, they are the directors. They say that we have voluntary before the police disclose everything. That means a judicial extrajudicial confession before the police. Now, they did not forward me to the court of law to record it. So this material on the basis of accused statement, which is a specific bar under the code itself, they are relying on it to frame me. Anyway, sir, as per this provision, he is admitting to the fact that the maximum punishment is 60 years, 60 days, you can keep behind the bar. Today is 33 days. Previously, 4 days or 5 days police custody was taken of us. Now, as per old act, first 15 days, a person can be taken into police custody, not thereafter. The new law says in a 60 days, where is the 60 days imprisonment is there during investigation, first 30 days, one can be taken into custody. Again, police custody, not after that. That period is also over. They doesn't require me after initial police custody. They doesn't require me because they have never asked for police custody for that purpose. So why my detention is necessary? They have seized all the documents. That has been part of the record. That is on the merit of the case. If at all, my lord, he's been submitting, we are from a good family, my lord, we'll face the trial. For that purpose, why my detention is necessary? So far, with regard to, my lord, the law, Darshan Singh, I'll come to that. Darshan Singh is altogether on different footage. Here, my lord, will kindly read section 62 of the BNS. Kindly see, nobody points out, and the learned BP doesn't point it out. What, my lord, this 62 says about it? 62, before amendment, it was 60A. Amendment to the CRPC was brought in, and that was 60A. A provision has been inserted, and that provision also been replicated in the new law. What 62 says? No arrest shall be made except in accordance with the provision of this Sanjita or any other law for the time being in force provided for arrest. So that means the mandatory provision that has been the Indian Parliament amend the law in view of the Supreme Court directions given to the all the courts and the police officers. It is not only police officers, it includes the courts also, Anish Kumar. So, my lord will kindly see and appreciate the fact that this is to stop the police, my lord, high-handedness with regard to dealing with cases, to minimize and limit their power. And for that, 35 is been incorporated. And in 35, Anish Kumar, I have shown it, that it is sine qua non. They have two reasons. Just arrest memo, yes, no, yes, they are sons of absconding. That will also not do, because they can by way that they can defeat the very purpose for which Supreme Court has given a directions. There has to be reasons on writing in the case diary that these are veteran criminals. They have involved in other cases, so they may flee from justice. That this will happen. Their own satisfaction will not do. Satisfaction based on material, reasons in writing. That's what 35 is saying. Now, my learned counsel, with all respect to him, is trying to interpret with regard to 47, 48. It's altogether different. 35 is a distinct offense, distinct provisions. 35 come into play before arrest. So whether notice is to be given or not. So on the materials on record and doing the homework, the police will come to a finding that there is chance of fleeing of justice because of these reasons. These reasons are absent in the case diary. That he can tamper with the evidence. Just statement will not do. There has to be reasons on writing. It is not there. So what I am on, 47, 48 is altogether different after arrest. 47 with regard to requirement to inform a family member is after arrest. And 48 with regard to ground of arrest to be served is after arrest. At the time of arrest, it is sine qua non that this has to be complied with letter and spirit. It is judgment to be. And this judgment of Darshan Singh is not in collision with this Ernest Kumar, because Ernest Kumar again been backed by my lord until judgment.
Until the.
And as on today, when there is been a violation with regard to a constitutional provision, I'm not going too far to the learned, to the submission. As for the affair, if an allegation is made against me, copy of the affair is to be furnished to me. It's not been furnished to me. I am not going to that extent. Only on 35, I am on that, my lord. Paragraph 15, my lord, will come to, my lord. This is my judgment of 26/3/2025, my lord.
Paragraph 15.
15, my lord.
Yes.
Somnath Supra Director, so and so, so and so, so and so, so and so, so and so. It took paragraph 15 in key decided. My lord will kindly say Ernest Kumar has been quoted again in the Supreme Court 2025 law. Recent judgment, March 2014 8 SCC court finds evident police misconduct but closes proceeding as related police so and so caution police and direct to prevent recurrent expression concern mechanical compliance of 41 B2 CRPC's checklist, reiterate constitutional bench judgment, so and so, so and so. Ultimately, it was referred. Yes. This was referred, my lord, because until is a good law and been relied on by Supreme Court as on now. Yes. Ito nalagay. And what I am on, the recent affidavit I have filed in yesterday, my lord, I have brought on record, my lord, will kindly see. I have explained that I'm trying to explain and assist this honorable court with regard to the law. Sujoy, yes, kindly see, sir. Wife has filed this, my lord. Will kindly come to, my lord, paragraph 6 of my recent affidavit. That is the law. And I try to interpret it with my limited knowledge, my lord. The accused petitioner states that the old Code of Criminal Procedure is subject to amendment by the Code of Criminal Procedure Amendment Act of 2008. By way of aforesaid Amendment Act and Section 41 of the Code was subject to amendment, and there was new insertion 41A, 41B, 41C, 41D. Further, new insertion has been made as 660A, which is now 62, my lord, in the new law, wherein specifically laid down that no person shall be made no person shall be made except made arrest, my lord. Arrest word is left out, my lord. Except in accordance. Yes.
In my copy, it's here.
Yes. Here, my lord, this is not there. But paragraph 7, kindly see, my lord. I have highlighted it. He has to record reasons in writing for his reasons to believe. That reasons to believe, my lord, will kindly come in 35. It has been reflected. Reasons to believe, my lord, I have underlined it, my lord. A to E reasons, my lord. Where so and so, so and so, so and so information has been received, so and so. Reasons to believe, my lord, that's been the word. If he has reasons to believe arrest, that reasons to believe is absent in this case. If he has reasons to believe that he has to issue a notice, that is also been mandatory, my lord. He has to record reasons in writing for his reasons to believe on the basis he should contain reasons to believe on the basis of material collected during investigation, not his discretionary, my lord. Reasons that if the person concerned is arrested, then he may commit further evidence. These are the things, my lord. And in paragraph, my lord, 8, I have stated, my lord, the accused petitioner states that the case diary will reveal that no such required reasons to be believed by arresting officer of the accused person is recorded, which is admitted by my learned friend. So I am entitled to bail. Why I should be behind the bar? Whatever is the case, I am not on the merit, my lord. I'll see in the trial. If they are, my lord, accused of this and prosecution can stand on their legs independently with regard to this, they will go to behind the bar. This is matter of investigations, my lord. 33 days they are behind the bar. I pray with Folder, let them come out, my lord, with stringent conditions, my lord. And they will cooperate with the investigation. And that's been the law, my lord. And Darshan Singh case is not at all here, my lord. What prejudice is called? What prejudice? Where is the question of prejudice? Wherein the statutory provisions that has been laid down by the Supreme Court has been violated. On the basis of Supreme Court judgment, my lord, the legislature amended the law and made it mandatory. You are violating it. The Supreme Court says it's mandatory. Coordinate bench is saying it is mandatory violations, my lord. Where is the questions, my lord, to keep myself behind the bar, my lord? With any condition, I am ready to abide by this. My lord will kindly see paragraph 25 of until, my lord, and Satyendra Kumar until case. 25 is very important. Why it is mandatory, my lord? 41 is 35. The consequence of non-compliance with section 41, which is 35, shall certainly ensure to benefit of the person suspected of the offense, resultly, while considering the application for enlargement of bail, court will have to satisfy themselves on due compliance of these provisions. Any non-compliance would entitle the accused grant on bail. This is until. So that's been clear case admitted by the learned PP. What else is
No
remaining?
notice has been issued.
My lord?
This is if notice is not issued,
Absolutely.
but no notice was issued in this case.
No. And that's the coordinate based judgment. That is the Supreme Court interpretation, my lord. That is my respectful submission. my lord.
Please give me the book.
Yes, yes. Kitabkhan
Please
details.
give me that judgment. Darshan,
Read here, Darshan.
you want to try again? No.
Regarding until and Lordship, Ernest Kumar judgment, Lordship. Yeah, Lordship, that is, it is clear, Lordship, that Lordship, it is not mandatory that 47 notice has to be given, Lordship. 41A or 45 notice has to be given. If they are
No,
being,
in this case it is.
no,
it
if they are,
has
no,
to be-
Lordship, if they are,
has to be done.
if they are released, if they are allowed to go, even after if they asked to come after interrogation, if they are allowed to go, then 40 that the notice has to be 41 a notice has to be given.
Something,
And-
notice has to be issued. and-
Absolutely, my lord. If notice is not been issued, reasons to be recorded in writing has to be there. That is not there.
That is notice. If sometimes Lordship, what happen, person is being called for giving notice call for after interrogation, Lordship, it seems that his arrest is required.
Yes, that can
In
be
that
done.
case, Lordship, we instead of giving him notice for 41A notice or 35 notice, notice, he will be arrested, and at the same time that checklist has to be
Yes.
prepared and it has to be submitted in the court below.
Good.
That is, Lordship.
Absolutely, he's right.
That is.
Which is admitting that the checklist doesn't contain this.
That I am admitting, Lordship. I'm from the
And
very beginning. I'm
nothing
admitting,
is
Lordship,
written,
that is-
my lord.
but
This
Lordship,
will get it in the CD only.
Yes, sir, let the CD see, my lord. CD, my lord, on the last occasion when it came, my lord, a lengthy argument, CD has been perused by the court. It was not there. It cannot be there because
it
it
is
is
not there,
before
Lordship.
arrest.
No, I am
Because it was admitted by the learned
I was
PP.
from the
I was not.
Not there, my
From
lord.
the
It was
very
some
beginning,
other court.
I am
Some
from-
other court, my lord.
from
That's
the
why, my lord.
very beginning, I am submitting that those 3-4 columns are blank. It is
Admittedly,
given,
my
it is not some columns are bigger, but my submission was that, Lordship, whether for that procedural lessons he is entitled for bail or whether he is that for that non-compliance, he is by any way he is prejudiced. He has to be prejudiced.
Obviously, a
and that
person is
that
behind the bar,
Lordship.
he is prejudiced, my lord. If he has to be behind the bar for non-compliance with mandatory provisions, suppose in 22, my lord, Honorable Justice Ujjwal Bhuiyan judgment in our High Court. Now a person has to be produced before within 24 hours. It has not been produced. I argued that matter before this honorable court, before Justice Sharma, my lord. And he said it. And for that purpose, I give it a footing that more than 24 hours he kept me behind the bar. And this is the sub and substance. 22 violation. Immediately bail been granted. So these are mandatory provisions, my lord. Every minute, every second is illegal detention. By the admission of the learned PP, he is very fair with regard to the law. I respect him for that. But when it is admitted, this is not been complied with. Case ends there, my lord. That's my respectful submission.
Well, Lordship, I will find it. I will submit the Darshan judgment after some time.
Judgment, book also you have referred to until.
Until.
Submit a book.
And
You'll get it back today evening. that
yes,
Book.
yes. My lord, 3 cases, same, my lord. Same. All tender years.
That annexure numbers are also similar.
Yes, my lord. Similar, no?
If not, then I can find out.
My lord.
I'll go through each and every.
I don't want to
case.
travel these vacation days, my lord. That's why, my lord.
No,
I take the leave, my lord.
I wanted to help you also.
Yes,
Yes.
if we oblige for that, my lord.
So
Nobody is
we-
born criminal. Some may have happened on the merit. I'm not going in, my lord. Only on mandatory provision.
Item number 15.
May I please, your lordship? Your lordship, 483 Business application, your lordship. The CD was called for, your lordship. The case was.
You have the CD?
We have not received a case, your lordship.
Okay.
There's registered 108, your lordship. Page number 9 is the vernacular, otherwise, your lordship. Your lordship, export immediately after vacation, your lordship. On 13th, your lordship.
Having the file? 15?
Lordship.
CDS corporate is not received, issue reminder list the matter on 15.
Item 16.
Ranjana Kalawat. Lordship, it was gone through by Lanet PP Ranjan Bora. So after some time, follow you. I have a
Item 17.
May I please?
Yes, yes.
My lord, this is a regular bail application, my lord. This matter, my lord, the case diary along with the medical report was called for, my lord. In a NDPS case, my lord, one lady was arrested.
Oh,
my lord.
yes, yes, that the
Yep.
lady who is in
Yes.
ICU, no?
Subsequent to your lordship order, my lord, she has been shifted to GMCH.
Oh, she has been brought here?
Yes, ma'am.
Receipt a case there,
And only if last time, my lord, on merit, I did not submit much because here, my lord, kindly said recoveries, my lord, have been made from a different person, 2 persons were there. So, and it was my lord, a huge recovery around 1,400 plus kg, my lord. So that lord should find, my lord, from my lord, the FIR itself, my lord. And my lord, the 2 persons who were from whom the recoveries were made, my lord, 1,000.
97 kg.
1,497.
Ganja?
Yes, my lord. It was from a container truck, my lord. It was kept, my lord, concealed. Thereafter, my lord, the allegation, my lord, against
Be truck or it will be that
container,
petrol
yes,
carry-
yes,
petrol
container,
carry-
it will be
What
container.
is it called?
Container.
It's called trucks, no, that
Container
carrying petrol?
Huge box was there, lordship.
Okay, okay.
Container. my lord.
Container.
So now, my lord, so for the allegation against the present, my lord, accused, my lord. Here, lord should kindly see page 22, my lord, once, my lord. So that, my lord,
You have the CD, no?
Yes, CD
Medical
received.
report.
Medical report is not received yet, lordship.
medical line.
Good.
Medical report not received yet.
Can
Only
we
the-
fix it tomorrow for a medical report?
I
We
think
need the medical report because we basically heard bail is based on medical report.
I'll leave it to law. Otherwise also, my lord, what I mean, my lord, 1,400 kg and she got 5,000 rupees. That is the allegation. That means for 1 kg, 3 rupees like that. But why I'm stating, my lord, because
Yes, yes, I understand.
if it is such a huge, my lord,
CDS, her CD has not been submitted,
no.
no?
Then
Tomorrow,
my lord.
tomorrow we will call for a medical report.
Otherwise, my lord, then
It's not
From which
from
day?
delay.
Huh?
she is in GMCH, my lord. Let it be fixed tomorrow, my lord. Thereafter, we will take a chance. Otherwise, on merit also we may submit.
Yes, yes.
I have communicated with the IO lordship, and lordship, he has informed lordship that the report has to be, it will be furnished from the jail authority. So lordship, and he has already been shifted to Guwahati. He has already been shifted to Guwahati, so he's getting some better treatment probably lordship, because from there to here, he's getting some Guwahati GMC. He's
She woman.
she is getting some better treatment. So lordship may fix it on immediately after vacation, lordship. Reporting lordship 13, 14, any date.
Report will come on which date?
My lord,
Till then,
can I
come
intervene,
lordship.
my lord? No. It is up to the court to decide and kindly see, my lord, lady.
Come from which
Yes,
place?
we can-
which side? I am submitting.
We can come from the GMCH, yes, she has been
GMCH.
shifted here, my lord. Somebody will,
Lordship may kindly give some 2-3 days lordship, so that lordship it will come lordship.
my lord, let it
Because
be
lordship-
then hard on merit, my lord. Somebody will object on each and everything, my lord. Lordship has stated it's your lordship discretion. Lordship will kindly fix it tomorrow as your lordship has stated, my lord.
You cannot bring it tomorrow?
We'll take a chance, my lord, if it doesn't come, my lord. Kindly, my
It
lord.
will come lordship, because definitely because it will come from delay lordship, and it will not come
From
lordship
where?
because before some time I talked with the IO lordship, and he told me
It
lordship
will come from which place?
delay.
Eli?
Eli is the
PS,
police
PS,
station, my
yes,
lord.
yes.
She has been
Which police
shifted.
station?
Delay
Cardiac
PS,
law, my lord,
cardiac law.
Cardiac.
Cardiac law.
3 hours, my lord, 4 hours.
Now,
But that report is not prepared, or report is not available. Report it will be collected from the GMC. They have also made prayer from GMC to give that report. Even immediately after, they can pursue within the 2-3 days. And also, I don't know also whether what will happen also on 13th Lordship.
No, what will happen? It is not somebody is in the hospital and you are stating that let it be fixed after vacation. It is the discretion of the court. I leave it to the
Yes,
lordship's
can-
discretion, my lord.
can we bring GMC?
Yes, my lord. What is the harm? Yes,
But we
directly
can-
also.
Only thing is that it should be handed over by the IO of the from the GMCS. We cannot come call for the GMCS, but IO can collect and IO gave a send it to us. So it's from the cases on delay.
Lordship may fix it tomorrow, my lord, and he will take the instruction and he will talk with the IO and that direction will be, medical report is awaited. Fix it tomorrow, my lord. And others, we can go on the merit also, because kindly see, my lord, no recovery from her, my lord. For 5,000, my lord, she is inside. And the allegation is that there was some connection with her and she was not arrested with the accused person, that they were traveling together, my lord. It's not like that, my lord.
No.
It was recovered subsequently, they said,
100%.
yes, my lord. And there may be,
She's a woman
and there may be telephonic conversation. There may be telephonic conversation on CDR itself. There are several orders of the apex court also, my lord. There may be CDR records, my lord. Kindly fix it tomorrow, my lord, as your lordship stated, because thereafter, my lord, we'll see what happens tomorrow.
There are some glitches, you see, they won't be able to, because IU has to bring it.
My lord,
Yes,
that, my
that is
lord,
the problem.
kindly see now move so fast, my lord, nowadays, my lord. IO can talk today itself, my lord, with the superintendent. And he can give it through mobile also, not necessary him to come, my lord. He will provide it, my, let it be
Try for tomorrow.
kindly, my lord.
But only thing is that we have to send a message to IO can collect.
Try for tomorrow, let's see.
Kindly,
From AMCH, she's taking treatment in AMCH.
GMC.
So-
GMCH.
Yes, GMCH. not
After
AMCH.
lordship's order, my lord, we send it then thereafter, my lord.
She's taking treatment in GMCH, you see. So you see, maybe treatment will be very good. I think best of the treatment she'll be getting. But even then we will need a report, because they're stressing on this one. And then we have only 2 days, today and tomorrow.
Yes, yes.
So let's try,
Try, let us see, my lord. Kindly.
Then otherwise he will submit on
My
merit.
lord,
then.
fine.
Medical Learned Counsel Mr. A. Chaudhary is present for the petitioner. Learned Counsel Mr. Learned Counsel Mr. G.P. Goswami is present for the respondent. CD is received. It is submitted that a medical legal report of the victim has not been forwarded. The victim is undergoing treatment at AMCH as she was shifted for proper treatment. Shifted SHIFTED. Shifted for proper treatment at AMCH. Oh. I go back to my hometown.
You go to hometown.
GMCH, full stop. To consider a bail petition, the medical report is required. To consider the bail petition,
Yes.
call for a report from the AMCH.
GMC.
GMCH on call for a report from the GMCS relating detailed report. Call for a detailed report relating to the health of the petitioner. Victim relating to the petitioner from the GMCS on 9/10 positively without fail.
My lord, highly obliged.
Prosecution to call for a report and
Highly obliged.
positively without
Much
fail.
obliged.
CD to be retained till 9/10.
Obliged.
Item 18.
May I please lord?
Yes, yes.
Today, my lord, 58 days, my lord. In between section 21B, man. 11
Okay,
grams.
okay.
Lord.
Okay, 58 days, we will grant bail.
My lord,
Okay, under objection, we will grant bail.
18 months. 18 months. 18 months.
When if the CD is not there,
Yes.
we will grant bail. Under objection.
It is, we have received the case diary, but FSL report not received yet.
Not required.
I think it's 51.
18, no?
58.
Item number 18.
18 man.
Loyal counsel, Mr. Arali, no?
Lordship.
Arali, because your brothers, H. Hamid and Arali, your brothers. You look similar, both of you. I confuse. Always.
21B.
Learned counsel, Mr. R. is present for the petitioner.
11.
Soriful Khan, alias Soriful Khan, who has filed this application under section 483 of the BNWS 2023 with prayer for bail, as the petitioner is behind bars for, are you sure, 58 days?
Lordship, from 12/8, my lord.
Behind bars since
12/8/2025.
in connection with so-and-so PS case under so-and-so sections. Where is the FIR?
FIR, my lord, page 10.
By Mr. D.P. Goswami, learned additional PP Assam. It is submitted by the learned DP, learned additional PP that they are implementing materials in the case that against the petitioner. First off, I have considered the submissions at the bar is circumspection. I have also considered the length of detention and the substantial progress of investigation. It is true that they are incriminating materials in the case diary against the petitioner. First off, I have considered the submission that the petitioner is willing to cooperate with the remaining part of the investigation. First off, he is local resident or?
Lordship, local resident.
The petitioner being a local resident is not a flight risk, considering all aspects, the petitioner is allowed on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the CJ,
Lordship, he was forwarded CGM. my lord.
or it is pending in the trial court.
No, CD is here, my lord.
CDM, we have CDM on our side.
CJ.
Lordship,
CDM Borbet,
Chief Judicial Minister.
Satisfaction of the learned CJ Borpeta under the condition that the petitioner shall refrain from such activities with which is alleged, the petitioner shall not leave the jurisdiction of the court without prior permission on breach of any of the bail conditions. The court is at liberty to immediately cancel the bail granted to the petitioner and at the city.
Okay.
I think 19 for orders.
Orders are not Oh, okay, okay.
In that case, my lord. Only, my lord, the designation of the learned court, my lord, learned additional district judge Dibrugarh. It was written as session judge, my lord, in the order, my lord. In page 7, my lord.
It has to be session judge.
No,
It's a criminal case or civil case.
Civil case, my lord.
Oh.
Custody case, my lord.
No. Civil case.
Lord. Page 7, my lord.
Which way?
Page 7, my lord. In third line, my lord.
Page?
Page 7. Order dated, my lord, 19/9.
Oh. Guardianship case.
Lordship, guardianship case.
It has to be district judge. Custody battle.
Lord. Order passed by the additional district judge Dibrugarh.
Our counsel, Mr. Ali, for the petitioner in Nambu family photo case, who has filed this application with prayer for correction of a typographical error, full stop. It is submitted that
Order to this.
that there has been an inadvertent error wherein on the order dated 19/9.
19/9/2020.
19/9/2025 in connection with FAO 60 of 2025, comma, in paragraph, which paragraph we have to correct?
In first line, first paragraph, my lord, line number 3.
Comma, it has been erroneously mentioned in the first paragraph of the order that it has been erroneously mentioned again. The court has been erroneously typed as the court of the session judge instead of learned district judge Dibrugarh.
Additional district judge.
Instead of learned additional district judge Dibrugarh. Full stop. Anywhere else?
No other.
So this error is allowed to be rectified and typed as the court of the learned additional district judge in place of session judge Dibrugarh. Additional district judge Dibrugarh in place of learned session judge Dibrugarh. This order will also form a part of the order dated 19/9/2025 in FAO 60 of 2025. Okay.
Okay.
This application stands disposed.
Okay.
We have received the case diary, my lord.
Where is the FIR?
FIR page annexer A lordship, page number 9.
What is the
Investigate-
allegation?
Your lordship, page number 9.
Page number 9, okay.
Yes. That is the allegation is that the investigation officer while roaming as patrolling party, some transgender has roaming under the overbridge of Ganesh Guri, here to there. And they have tried to demanding money from the public and assaulted the woman. And accordingly, and they have also tried to
All right, all right. How many days you have given this?
26 days. Sir.
My lordship, kindly see one aspect of the matter, my lord. This is the incident of in the month of January, my lord. Now, my lord, they, my lord, damaged the, my lord, police vehicle, my lord, and they have also assaulted the police person, my lord. Now, my lord, again, my lord, in the month of September, my lord, they have again, my lord, started, my lord, hue and cry, and my lord, they are disturbing the, my lord, general public, my lord, while they were, my lord, moving in the Ganeshguri area, my lord. So that is why, my lord, they were arrested on again on, my lord. Not arrested, my lord. Earlier they were not arrested, my lord. Now, my lord, on the basis of that incident, my lord, they were arrested, my lord. On, my lord, 12/9/2019 to 2025, they were arrested, my lord. They are transgender, my lord, but they cannot violate law, my lord. They are disturbing disturbing the, my lord, general public, my lord, who are, my lord, comes to Ganeshguri, my lord, for marketing. And, my lord, also, my lord, involving antisocial activities, my lord.
That is only allegation, your lordship. It is well settled law that transgender has a equal right similar to us, your lordship.
Equal
Moreover,
right, my lord,
lordship,
but
in
for
the-
that purpose,
lordship,
lordship, may kindly say what is the timing, my lord?
your
12
lordship,
PM in the
although
night, my
lordship,
lord.
after 8 month back, lordship, the petitioner has been arrested, lordship. But lordship, no formal procedure has been conducted, lordship, as per the compliance provision of BNSS Act 35 subclause 3, your lordship. That is the mandatory procedure, notice should be issued. So herein, lordship, the annexer B, your lordship, page number 15 and 11 portion, page number 16, may I please to read, lordship. The arrested accused have been medically examined. Arrested of the accused have been made maintaining proper formalities and served notice under section 47 of BNSS and brief of the accused individually about the reason of arrest. Although herein mentioned that by compliance provision of under section 47 of BNSS Act, no ground of arrest has been furnished to the family member of the accused, lordship. Although they have furnished the ground of arrest to the accused itself, but it should be served to the family member of the accused. Moreover, lordship, very interestingly herein mentioned itself is the forwarding letter, lordship, that has been served to him, to his nominated person relative. That is the first statement made by the investigation itself. Your lordship, in view of the gravity of the serious nature of the offense involved and another alleged person mentioned in the FIR, and considering that the accused has a criminal antecedent and provision of issuing notice under section 35 of the Bharatiya Nagarik Samhita, BNSS Act 2023 was
Okay,
not
okay,
applied in
okay,
this case.
Right, but you
So,
have
your
to give
lordship,
antecedent also. So we will give you some strict conditions.
no, your lordship, at that
No,
time,
it's
lordship,
okay,
the
we will give you
petitioner
some
has been
strict
moving.
conditions.
Your lordship, petitioner has been moving under the overbridge of Ganeshguri. They have a right to free movement under Article 19(1)(a), your lordship. That is,
Hey, what you are saying? You
Your
are not listening to me, you are going on and on your own.
your lordship.
Why should you go under Article 19, 20, 21? I'm saying I'm granting you bail, but you will have to, but I'll give you some strict conditions because you have,
Exactly. Of course.
you have
And
antecedents.
your
You
lordship,
see?
I am bound to furnish all conditions prescribed by your honor.
Regarding 47, 48, my lord, these are all, my lord, complied with, my lord. Now it is 37, my lord.
You have got antecedents, so you have to, you have to abide by the conditions.
Exactly,
I'll give you
Why
bail,
not?
but
It's
under
my
strict conditions.
bounty duty. of
So
the
you are
petitioner.
from, we cannot get this permission of leave and also we cannot be done because your address is shown as Abhayapuri, Bongaigaon. But present address is Duramari, Lalmati. Your Lalmati, Duramari,
And my lord,
Abhayapuri,
lordship,
Bongaigaon.
may kindly say the address are very vague, my lord. Lordship may kindly say that Abdul Mazam alias Lavli Gill is so and so, son of so and so, post office Lal Mati, my lord. Post office and police station, my lord. Who is the residence of my lord? Police cannot search them, my lord, directly from the post office and police station, my lord.
His
Totally
family
vague
member
address,
is
my lord.
residing
Lordship may
here.
kindly say. Totally vague address, my lord.
Duaramari. Resident of Duaramari, Obhaipuri, Bongaigaon. Then the other is from which place? Nagaon.
Other is from my lord Borpeta, my lord. Post office Senga, district Borpeta, and there is no police station, my lord.
After furnishing bail bond lordship, the police will get everything. On
Two
Big
local
com-
securities then.
your lordship,
Two local securities from
your
Guwahati.
lordship.
Because they are from,
Compliance.
they are not from Guwahati.
Any condition, your lord. Bound to submit.
Lord Learned Counsel, Mr. M. Setia for the petitioner so and so who have filed this application given as a petitioner under section 483 of the BNWS 2023 with clear for bail, as they are behind bars since when were they arrested?
Lordship on 12th lordship. 12th September law.
12/9/2025 in connection with so PS case under so sections. Third, Mr. Ajay Goa, learned additional PP Assam. Post of the allegation against the petitioners is that they were creating nuisance, and when the police petrol vehicle came, they heard bricks and they tried to prevent the police from discharging their duties.
In creating nuisance, my lord, in the
Yes.
in the area, my lord.
That I have already
Yes.
recorded. The learned additional PP has raised serious objections stating that the petitioners have antecedents, their petitioners have criminal antecedents, full stop. They are not entitled to bail as they are aggressive by nature, full stop. I have considered the submissions at the bar with circumspection. I have also scrutinized the case diary. Indeed, they are incriminating materials in the case diary against the petitioners. Most of the petitioners have pledged PLED pledged to abide by any stringent bail conditions imposed upon them. Considering all aspects, I have also considered the substantial progress of investigation. Considering all aspects, both the petitioners named Nandita Giriva are enlarged on bail of rupees 50,000 each. With two local sureties of like amount to the satisfaction of the learned will be
My lord, CGM Kamrup, my lord.
CGM Kamrup, under the condition that the petitioner shall refrain from such activities with which they allege. The petitioner shall not jump the bail and cooperate with the trial. The petitioner shall not exercise threats to witnesses on breach, refrain from such activities on breach of any of the bail conditions. The court is at liberty to immediately cancel the bail granted to the petitioner. Send back the CD.